Good morning, Mr. Nierman.
Good morning.
Please get seated and be settled, and when you are ready, you may begin with your opening statement.
Thank you. Once again, I'm privileged to have my amazing wife, Lisa, here with me this morning. It's great to have her. I have just genuinely enjoyed getting to know you all through this process, and some of you know better through this process. Almost feels like a casual conversation with close friends and a little less like a formal job interview with 17 people. So thank you for that. One of the things that friends do is to listen carefully to each other. And you have certainly heard me. And as I've listened to you, I've heard three themes that come up repeatedly. And they are, how would you affect the outcome of cases? What are the most significant legal experiences that have prepared you for service on the court? And what motivates you to apply? And I'm going to answer each of those questions. First, how would I influence the outcome of cases? I believe that my effect on the court will be primarily felt in the areas of disciplinary and constitutional law matters. We have seen a substantial increase in reports of attorneys committing domestic abuse and having inappropriate sexual relationships with clients. When people graduate from law school, they are not given a right to practice law. They are given a license to practice law. And licenses can be taken away, and in some cases should be taken away permanently. We need to remember that the primary purpose of the disciplinary process is to protect the public. Regarding constitutional law, increasingly, some are saying that Iowa's Constitution should be interpreted based on the evolving standards of society. I disagree. Justice Scalia had a great picture. Nimrod was Noah's great-grandson, and he was a mighty hunter. And for millennia, Nimrod was essentially synonymous with someone with great hunting skills, until Bugs Bunny. Bugs Bunny used Nimrod as a sarcastic nickname for Elmer Fudd, the incompetent Elmer Fudd. And those cartoons so influenced our cultural vocabulary that today many reputable dictionaries include incompetent person as an alternate definition for Nimrod. But notice what we would never do. We would never look at a document written 150 years ago that referenced Nimrod and assume that it meant incompetent person, right? It didn't mean that back then. Yet that method of supplanting our constitutional protections is becoming increasingly common, and it is dangerous. Second, what are the most significant legal experiences that have prepared me for service on the court? In the interest of time, I'm going to just run through them real quickly. One, after college, I worked in claims for State Farm, and by my mid-20s, I was supervising some attorneys and negotiating directly with others. I oversaw trials, mediations, and depositions. Two, I finished law school in 2 years and graduated with high distinction. Induction into the Order of the Coif followed. Three, in the course of 2 decades of practice, including jury and bench trials, I have handled essentially every kind of case that the Supreme Court decides: criminal, constitutional, juvenile, real estate, business, and others. Four, I've practiced across the state, from O'Brien County to Des Moines County and most of the counties in between. Five, I've served across Iowa and around the country as an expert witness in state and federal courts. Six, I co-authored the textbook that is used at Iowa State University and elsewhere. And seven, I've served as a law professor, which has allowed me to see appellate law from 40,000 feet. This has been a great compliment to my own appellate practice. Third, what motivates me to be here? I believe that those of us who are greatly blessed are called to give generously. I'm enjoying the fruits of a highly specialized practice and the growing reputation of a national expert. Yet my desire to enter into public service is intensifying, to promote the rule of law and administrative innovation. There is so much to do. There is so much to give. And there are so many ways to make this state even better. And I come before you humbly asking for an opportunity to do just that. I welcome your questions.
Thank you. And we do have some questions. We will begin with Mr. Sukup.
Thank you. Good morning, Mr. Nierman.
Good
You
morning.
mentioned on being an expert witness. Which case sticks out the most to you, or your approach to it?
Yeah, one of the things that's been great about serving as an expert is that it's exposed me to so many different areas of the law, and a lot of them connected within insurance. So just recently I've been involved in a case that had a large intellectual property component. Last year I was involved in a case that involved securities litigation. A couple recently have concerned alleged attorney malpractice, and one in particular was essentially a attorney that produced a large result for the client. The client didn't want to pay the bill at the end, and so alleged malpractice. So that has helped me to not only touch a bunch of areas of law that I wouldn't have otherwise, but it's allowed me to travel the country and see other court systems and different ways of doing things.
Thank you.
Ms. Valentine?
Thank you. I'm not going to quote you probably exactly because I couldn't write fast enough, but you said something about there's so much to do and something along the lines of so much to do that we can do better.
Yeah.
Tell me what you think we can do and what we can do better.
Sure. I have a governmental client, and when I first started talking to them, they said, well, how much you charge? And I gave them the rate, and I said, but for these first couple cases, I'll give you a discount. It was almost 50%, and they came back and said, actually, we'd like you to charge your full rate because we're trying to convince the people that do the budget that we need more money for our department. And, it struck me that a lot of times in government, there's this perception that the resources that we need to improve are always somewhere else. They're in a different department, they're in a different branch of government, they're with the taxpayers, and we need to get more of that. And very often in the private sector, when there's an important new priority and there's not cash laying around to do that, the focus becomes, okay, we've got resources right here. How can we innovate? How can we do things differently? And very often, and that has to be coupled with continuing to give great customer service, or they're going to lose all their customers. So, if we look at some of the challenges that we're seeing, so the workload of the Court of Appeals, and the expansion of drug and family specialty courts. So we know that these specialty courts work. They're helping people to get off drugs, to reduce crime, and help families stay intact, people to contribute to the economy. And the glass is half full in the sense that we have at least one of them in about 25 counties. It's half empty in the sense that we've got over 70 that don't have any. So in January, I talked about mandatory mediation in civil cases. We could give better customer service. We can reduce the number of jurors that we need and not have to pay as many of them, and free up a bunch of personnel resources, judges, court reporters, clerk of court staff, et cetera. And then, as we have fewer trials, we're going to have fewer appeals. So that's going to help on the appellate level. And of course, as Alabama saw, I mentioned this last time, mandatory mediation at the appellate level has reduced the number of decisions that need to be written by over 55%. So those are the types of things that we need a catalyst who can say, hey, let's think about what we've got right here and how we can make that work for us.
Thank you.
Thank you. Mrs. Sinclair?
No questions.
Ms. Conover?
Mr. Nierman, earlier I heard you, I'm not going to quote it exactly either, but you were talking about interpreting the Constitution, and you used the word dangerous to describe taking some of the words out of context. And I'm curious about your philosophy regarding the principle of stare decisis and how you would incorporate that, follow that, whether that would be important to you if you serve as a jurist.
Sure. Yeah, so it's an important concept, just so we're all on the same page. It essentially means it stands as decided. So when a litigant comes and says, hey, I think the court should overturn a previous decision, the way that most courts have interpreted stare decisis is to say we have kind of this weighing situation where we're going to take the extent to which people have relied on our previous rulings, both in terms of time and quantity in a sense, and we're going to weigh that with how wrong the previous ruling was, if it was wrong. And that's kind of this weighing situation. And I think that's especially appropriate in tort cases, in the common law. We've had some controversy actually from both sides of the philosophical spectrum saying that is wrong when we're talking about statutes and the Constitution. And the argument there is that if we have wrongly interpreted a statute or the Constitution, we're not going to weigh things because we've essentially taken power away from the people and or the other branches of government. And so to perpetuate that wrong would be even worse than perhaps inadvertently committing that wrong in previously. A couple predictions. I think one is that we're going to see this latter way of thinking about statutes and Constitution be more common. And again, as we've seen in some of the opinions or at least one of the opinions from the Supreme Court, well, a couple actually, it's coming from both sides of the political spectrum. And I think the context here is that our country is increasingly politically fractured, and so there's a lot of desire for making changes. And the second one, kind of related to that, is that this is going to put a premium on collegiality. I think the judiciary has a great opportunity here to lead in terms of how people that disagree with each other communicate. Dissents can be scathing, they can be sarcastic, or they can be respectful. And I think that especially as we see what's going on around the country, that these leadership opportunities to lead by example, to be respectful with people that we adamantly disagree with are just very, very important.
Thank you. Mr. Berger.
I have no question.
Mr. Goodman.
No questions. Mr.
Bloom.
Well, just following up on that, I'm thinking of the Dred Scott case, perhaps one that was needing to be reversed. We possibly could have avoided the Civil War had the justices found a different way to decide that case. So, I mean, there are examples where the Supreme Court has gotten it horribly wrong, and it's not always right to follow precedent, I guess is my point. Would you agree with that?
I would, yes. And again, we're trying to do two things. We're trying to create stability. We've made a decision, people have relied on that, and we don't want a situation where people can't kind of predict what the Supreme Court is going to do. Cases are not going to settle or settle as often in that sense. And, more significantly, people, businesses aren't going to know how to conduct their lives without that predictable guidance. So overturning precedent in general terms should be rare, but I agree with you that there are times when it's necessary.
Mr. Bevel.
I'm sort of chuckling. Maybe it's not funny, but I think Plessy's a better example than Dred Scott because without the Civil War, I might not be here. We're talking about precedent. what do you do to decide whether you're not going to follow it?
Yeah, so in general, I think the momentum is to follow it. And I think, like I said, there has to be some very, very compelling reasons to not follow it. And, part of our system is that everybody follows precedent. The Supreme Court follows precedent. The Court of Appeals follows the Supreme Court's precedent. And the trial courts follow the precedent that's set by the other courts. And so we need stability, we need predictability, but there are some compelling circumstances where cases need to be overturned. And I know you're asking for a more specific answer, and I think that I think that the text is primary. That especially when we're looking at a statute or the Constitution, that is most revealing of what the people and their representatives wanted to happen. A lot of times in legislative context, words are chosen with incredible precision. I'll support your bill if you change the or to an and that reflects the will of the people. In terms of, it's interesting because I think everybody agrees, or almost all judges agree, that when we're interpreting a statute, that the intent of the legislature needs to control that. The disagreement is about our Constitution, and there, the judges are, I think, a little more diverse in their opinions, and I think that the intent of the people need to control that as well.
Thank you.
Thank you. Ms. Law?
No questions.
Mr. Spies?
Good morning.
Good morning. Excuse me.
Sorry to catch you mid-swallow. Mr. Nierman, is there an appellate judge or a Supreme Court justice, either of the Iowa Supreme Court or the United States Supreme Court, whose intellectual proficiency or means of expression you most admire or aspire to emulate?
I wouldn't say there's just one. I would say that...
and I ask that knowing you're a student of the law and the history of the law.
Sure. I think some of the newer justices we don't know as much about, but certainly Justice Mansfield, Justice Waterman, those are people that I find myself connecting with a lot. Certainly what I've seen from Chief Justice Christensen and Justice McDonald, I resonate with a lot.
Thank you.
Thank you. Mr. Horbach? No questions. Ms. O'Brien?
Thank you. Mr. Nierman, I am going to, I think, talk a little bit about the elephant in the room. And I hear on Iowa Public Radio over the last 2 and 3 weeks, members of the legislature bragging about changing how this commission is composed and appointed, and how when they get their people in there, it's going to change the way things are done and change certain decisions. Would you please comment on that?
Well, I think that's inherently a legislative public policy decision, and potentially, a bill could be passed, that could be challenged, I could be on the court, and I would have to make a decision about that. And so I don't think it would be appropriate for me to say whether I think it's a good idea to change it or it's a bad idea to change it. But I do believe that the legislature has been given authority as the people's representatives, and within the bounds of the Constitution, they have the power to make changes.
Thank you.
Well, we have time for one quick question. Mr. Hoytik.
You mentioned the importance of certainty. As somebody who advises a business, I think the hardest thing for me to do is to tell our leadership, I don't know. It's unclear. We can live with whether I agree or disagree with a certain path. As long as it's clear, we figure it out. How would that inform your how would that inform your legal writing when you're a Supreme Court justice?
Yeah, there's a balance because you want to decide the case that's at hand, and you don't want to, add a ton of dicta. Dicta is the legal word we use for part of the Supreme Court opinions. It's maybe not directly applicable to the case. I think that when the court goes too far afield from deciding the issue at hand, that it actually creates more uncertainty. That an abundance of dicta actually ends up sending different signals. So I think I would steer a little bit more toward keeping the opinions tight.
Thank you.
Well, Mr. Nierman, thank you for being here today, and I'm sorry that we are out of time, but we wish you well, and thank you for bringing your wife with you today.
My pleasure. Thank you.